Hello! Today in this video, we are going to be discussing how to answer law school exam questions. This is a really important video because unlike most people's undergraduate careers or programs, your law school grade for each course largely depends upon one examination, meaning you'll take a whole course, do a ton of work, but your overall grade will be dependent on your performance on one exam. That's a lot of pressure. So it's really important that you practice how to answer law school exam questions so that you can, of course, score the best as you possibly can. So how do you do this? First, it's best to be familiar with the IRAC formula. IRAC is IRAC. That stands for Issue, Rule, Analysis, and Conclusion. The great thing about the IRAC approach that you should be utilizing when you practice and respond to law school exam questions is that IRAC is very formulaic. Once you've spotted an issue, the I stands for issue, you would then set forth the rule. You could literally write the rule is and insert the rule. Then comes the A of IRAC. That is your analysis. And you would write something like, the court would analyze this in the following way, or plaintiff's argument is insert argument, or defendant's argument is insert argument. Then finally, the C of IRAC is conclusion. And again, you can treat this very formulaic and you could say something like, it's most likely that a court would rule in favor of plaintiff or defendant, or insert whatever conclusion makes sense. So let's break down this IRAC formula even more, starting first with the issue or the I. What makes law school exam questions unlike most types of exams you've probably taken before is that usually when you sit down to take this exam, it's quite lengthy. Usually it's a few hours that you're allocated to respond. And what you'll find is that you have these long fact patterns. Maybe there are a few, maybe there's one very long one. All of this will depend upon your class and your specific professor. But your job is to issue spot. Most of the time, they give you this long kind of story or a long fact pattern. And at the very end, it will say something like, discuss the issues or discuss. So it's your job to go back through that fact pattern and be able to identify all of the applicable issues that you should be assessing in response to that question or fact pattern. So that is why your I of IRAC is issue. It's key that you identify all, if not most of the applicable issues. Because if you can't identify the issues, then you will not go on to discuss the relevant rules of law, and then of course analyze it, and then of course reach conclusions in response to the issues presented. This is unlike most exams you've taken before, at least I would assume. So this is a skill you want to practice. This is why you want to actually practice taking exams before you walk into any of your final exams for law school, because issue spotting is unique. It's something that most people do not get good at without practice. So that is the I of IRAC. Moving on to the R, or the rule. Here, you're going to write down all of the relevant, if it's singular, rules in response to the issues that you have spotted. This is why it's very helpful to have a well put together outline, and of course, having reviewed that outline or memorized that outline if it's a closed book exam, or be very familiar with it if it's an open book exam. You want to be able to show your professor that you can not only identify the issue, but you can also state and give them the relevant rule. Hence the R in IRAC. One mistake that a lot of students make is they outline dump. Outline dump is the idea that you just write down all of the rules. And this is unfortunately a terrible approach because your professor can't and won't give you points for simply writing down all of the rules. Why? Because your professor simply wants to see the relevant ones as it relates to that issue. And I think the more familiar you are with your outlines and of course the subject matter and topics discussed in class, knowing what is relevant will become easier upon review and upon practice of issue spotting and of course familiarity with those rules that could be tested. So that is the R. Next, moving on to the A of IRAC, or your analysis. This is arguably the most important part of your law school exam response. This is likely where you will get the most amount of points. And remember what I said about the I of IRAC. It's the issue spotting piece. It's really important that you can spot issues so that you can go on to provide the rule and the analysis that's applicable to that. Because again, this is where in the analysis section, you're going to get the bulk of your points in response to that question. Here in the analysis section, to break this down, this is where you're applying the law to the fact patterns, or the law to the facts, so to speak. But it's important to note how to take your answer from an average answer to a high scoring, possibly A+ type response, because obviously most students' goals are to get those high scores on their law school final exams. So what is the difference? How can you take your exam from average to A+ worthy? And you do this by treating your analysis section like a work of art, A-R-T. So what do I mean by that? When it comes to your analysis in IRAC, you do not simply want to just write about what the court would think or how they would analyze the scenario. That's an average answer. A stellar answer or a high-scoring response treats their analysis like a work of art, A-R-T. So what they will do instead is they will set forth the argument that the plaintiff would make, the A of art. Then they will follow that up with the response, the R of the art. The response is how the defendant or opposing party would respond to that argument. And then the T of art is tell us who you think is right. Basically, evaluate those arguments in your art and reach a brief conclusion about who has the stronger, better, winning argument from those that you've wrote down. It's important in your analysis section that you complete as many works of art as is necessary based on that issue. So what I mean by that is that you write down all of the applicable arguments that plaintiff would have in that art format. So that's, again, where you're spelling out plaintiff's argument, defendant's response to it, and then you're evaluating them, the T. And you do that as many times as is necessary to run through all of the reasonable arguments you could make for plaintiff. Then you would do the exact same thing for defendant. What are all of the arguments defendant would have as it relates to that issue? And again, treat it like a work of art. And you would do that as many times as is necessary to get through all of your applicable reasonable arguments for that issue in which you've decided to analyze. A lot of people often ask, what types of arguments can I make? How can I come up with that many arguments? You keep talking about maybe multiple works of art, so to speak. So, how can I get better at crafting these arguments? So we have a few tips for you in this department. You can argue that the facts should be interpreted one way or the other. That could be one type of argument you can make. You could argue that the law should be interpreted one way or the other. You could argue or cite policy reasons, and this is especially helpful and something I would recommend if you find that your professor is spending a lot of time in class discussing policy issues with you on certain issues. So that's something that can help you craft arguments for your art sections or the A of your IRAC. Another approach you can take to crafting arguments is maybe you learned differing approaches. Maybe there are different rules, like a majority or a minority approach that you learned on some sort of topic. You could craft arguments using those different approaches. You could argue that the majority rule should apply or that the minority rule should apply. And again, that can be helpful in running through different arts or different ways in which you can expand your analysis section of your IRAC. It's also helpful to remember that most of your arguments should be based on classroom discussion. I talked in a different video about how to outline in preparation for your law school final exams. And I talked about how when your professor gives you examples and hypotheticals, that's important for you to include in your outline. This is like a little sneak peek as to how your professor thinks and types of questions or ideas or facts they could give you on your final exam. So if you find that a fact pattern is similar to something that you discussed in class, you want to craft arguments that resemble those types of discussions that you guys had in class in response to those issues. Then finally, the C of IRAC, your conclusion. This is something that a lot of people struggle with when they practice final exams. It's really important that you show your professor that you can reach a conclusion on the issues presented. In other words, you are evaluating overall who has the better argument. How is this issue likely to play out? It's okay if you want to kind of have a soft conclusion, or at least that's how I describe it. A soft conclusion is if you said something like, it's most likely plaintiff would win, or it's most likely defendant would win. This way, it's not too strong of a conclusion. So if for whatever reason you're reaching a conclusion that your professor does not agree with, it doesn't sound so bad. You're leaving room open for argument. But what you want to make sure you avoid is failing to conclude at all. Sometimes people reach conclusions that are really not a conclusion at all. They're totally inconclusive, where they'll say something like, it's not clear who will win. Well, that's not really a conclusion at all. That's showing your professor that you can't, or you don't have the ability to reach a conclusion based on that legal issue. So you want to make sure that you're fully following IRAC, you're spotting those issues, you're writing down the relevant rules of law, you're analyzing those issues using our ART format, where you give the argument, the response to that argument, and then you tell us who you think is right, and you do that as many times as possible to work through all of the reasonable arguments you can make. And then finally, you conclude on the issue, your C of IRAC. So a lot of people often ask us, well, now that I know how to answer a law school final exam question, I need to practice. Where can I get practice questions? And this is a great question. So it's something that's important to think about. The best way for you to get practice for your law school finals is to track down previous exams from your professor. I know some professors post these on their online platforms where you get other documents for classes. I know other professors put them on reserve in the library depending on your law school, but it's important that you ask if they have any available, and it's also important that you ask if they have any model answers that go with that exam. Sometimes we find professors do not provide a model answer, but they will instead provide a high-scoring student response that you could use to kind of self-grade your own practice with. If you can't track down any law school practice exams or previous exams from your professor, you could pick up a supplement. Use something like Amazon or your law school bookstore to see if there's some sort of supplement out there. For instance, Examples and Explanations is a good supplement where you can practice your application of the law to brief fact patterns. Another resource that you can consider is simply taking to the internet. Use Google and, search for whatever type of final exam you're looking for. You might find that other professors at different schools have made their previous exams available, and that's something that you could download and utilize. It's obviously not as good as your own law school professor's previous exams, but at least it's practice, and practice is really important here because, like I said at the beginning of this video, writing and responding to law school exam questions is very likely unlike anything you've ever done before. So it's something that you do want to try your hand at and really give it a go with practicing. So that way you can get better at these skills. But on that note, not only is it important that you practice, but it's also important that you carve out time to self-grade. What is self-grading? The idea behind self-grading in the context of law school exams is if you sit down to read a law school fact pattern and to draft a response to it, don't simply read the model answer and then move on. Instead, you should plan on spending a large amount of time comparing the answer that you crafted and created in response to the model answer or the high-scoring student answer or whatever answer you're using to kind of score your own response. So when I say self-grade, what you want to be looking for is to see whether or not you've identified all of the issues that the model answer has identified. And if you missed any, go back through the fact pattern and see if you can figure out how or why you missed them. That way you won't miss those types of issues in the future. I mean, after all, the whole purpose of practicing is to get better. So if you're not taking a step back and assessing what went well and what needs improvement, what is the point of practicing? So not only can you make sure that you spotted all of the issues, but you can also test your rules. Did you write down the relevant rule? Was it accurate? Did you write too much? Did you write too little? And again, figure out how to correct those mistakes in the future. When it comes to your analysis, assess your arts. Did you make all of the reasonable arguments? Did you respond to them? If you missed any, try to go back and figure out what you missed and how you missed it. Then finally, assess your conclusions. Did you reach the same conclusions that the model answer did, or are yours different, and why? Again, you should be spending and allocating a pretty large amount of time to do this. Again, there is no point in practicing if you're not taking out time to figure out what went well and what needs improvement. The whole point of practicing is to improve. So when your actual final exams roll around, you're in good shape. And of course, you're in the best position possible to get that high scoring response that I know everyone wants in law school. Finally, I have a few tips for you all when it comes to kind of like a stylistic approach to responding to law school questions. This is not the time to obsess over writing perfectly. Again, you do not have to have perfect sentence structure or grammar. Your law school professors are not expecting this. Usually law school exams are timed and they're lengthy, so they understand this when they're grading your response. But you can do a few things to make your answer easier to read. We are firm believers here that if your answer is easier to read, it's likely going to be higher scoring. So a few things you can do is you could use headings. You could bold and underline those headings for the different issues in which you are spotting and assessing. This way it's easy for your professor to kind of check all of your issues to see if you've spotted all of the same issues they have. This makes it easier to read. You can use paragraph breaks. I find that when people oftentimes practice law school exams, they have these very long pages of issues and rules, analysis, and conclusions with no paragraph breaks. It's really hard to read. I feel like the natural reaction to that type of work product is to kind of gloss over things. You do not want your professor to be glossing over, your issues and rules and analysis and your conclusions. So by inserting paragraph breaks, you're going to make it easier to read. You can also draw positive attention to things that you know you're doing well. So if you spotted an issue and you're very confident about the rule or about the arguments that you're making, you can bold and italicize them. Again, don't bold and italicize everything because that gets very distracting and challenging to read. But you could say bold and or italicize the elements of a rule in which you're assessing. Because again, that's positive attention that's drawing your professor's eye to those things, which in the long run will really help bolster that grade. So overall, we hope that this video helped you. Remember to follow the IRAC format in responding to law school exam questions. That stands for the issue, rule, analysis, and conclusion. Remember to treat your analysis like works of art, ART. Write down the argument, the response to that argument, and then tell us who you think is right. In other words, evaluate those arguments. We hope you found this video helpful, and best of luck on your law school exams.